To an unusual degree in the history of the court, Justice Jackson wrote as he felt. In his case, the style was the man. He wrote as he talked, and he talked as he felt. The fact that his opinions were written talk made them as lively as the liveliness of his talk. He had impish candor, to borrow one of his own phrases. Candor, indeed, was one of his deepest veins. There was nothing stuffy about him, and therefore nothing stuffy about his writing. No man who ever sat on the Supreme Court, it seems to me, mirrored the man in him in his judicial work more completely than did Justice Jackson. His speech breaks through the printed page. He was one of those rare men whose spoken word survives in type. Another friend said that he had a reservoir of learning from which he drew gracefully and effortlessly. But the most marked quality of his judicial and non-judicial writing was not the ability to borrow an apt quotation or to find an idea well expressed by one who had written before him. It was the ability to think brilliantly in original and bold fashion and to express his thoughts in forceful and eloquent English of a style inimitably his own. His writing was pithy and pungent, yet he never sacrificed clarity of thought for a well-turned phrase. He was a master of the paradox. He had a great love of alliteration, and his antithetical statements were gems. Yet his wit never descended to the frivolous. It always added a barb to the telling point. His wit was especially telling when turned upon himself or his court. Examples of his wit abound. In a 1951 ABA Journal article about Supreme Court advocacy, he said, "I used to say that as Attorney General, I made 3 arguments in every case. First came the one I had planned, as I thought logical, coherent, complete. Second was the one actually presented, interrupted, incoherent, disjointed, disappointing. The third was an utterly devastating argument that I thought of after going to bed that night." He went on to say, "On your first appearance before the court, do not waste your time and ours telling us so. We are likely to discover for ourselves that you are a novice, but will think nonetheless of you for it. Every famous lawyer has had his first day at our bar, and perhaps a sad one. Be respectful, of course, but also be self-respectful, and neither disparage yourselves nor flatter the justices. We think well enough of ourselves already." In the 1953 case of Brown versus Allen, Jackson said, "Reversal by a higher court is not proof that justice is thereby better done. There is no doubt that if there were a super Supreme Court, a substantial proportion of our reversals of state courts would also be reversed. We are not fallible, and we're not final because we're infallible, but we are infallible only because we are final." Jackson's exasperation was quite apparent in the 1947 case of SEC versus Chenery Corporation, when he wrote in dissent that the court's reasoning adds up to this: the commission must be sustained because of its accumulated experience in solving a problem with which it has never before been confronted. I give up. Now I realize fully what Mark Twain meant when he said, "The more you explain it, the more I don't understand." With charming candor, Jackson freely admitted his mistakes. In Massachusetts versus United States, he wrote, "Under these circumstances, except for any personal humiliation involved in admitting that I do not always understand the opinions of this court, I can see no reason why I should be consciously wrong today because I was unconsciously wrong yesterday." Again, in writing about one of his own Attorney General's opinions that he believed should be overruled, he said in a concurring opinion, "I am entitled to say of that opinion what any discriminating reader must think of it. It was as foggy as the statute the Attorney General was asked to interpret." Then, quoting Lord Westbury, he wrote, "I can only say that I am amazed that a man of my intelligence should have been guilty of giving such an opinion." Professor Charles Allen Wright believed that Justice Jackson's dissent in the 1944 case of Korematsu versus United States was the most eloquent judicial statement ever made describing American democracy. Jackson wrote, "Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. There is no suggestion that apart from the matter involved here, he is not law-abiding and well-disposed. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born, and where all his life he has lived. A citizen's presence in this locality, however, was made a crime only if his parents were of Japanese birth. Had Korematsu been one of four, the others being, say, a German alien enemy, an Italian alien enemy, and a citizen of American-born ancestors convicted of treason but on parole, only Korematsu's presence would have violated the order. The difference between their innocence and his crime would result not from anything he did, said, or thought different than they, but only because he was born of different racial stock. Now, if any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. Even if all of one's antecedents had been convicted of treason, the Constitution prohibits its penalties from being visited upon him. But here is an attempt to make an otherwise innocent act a crime, merely because this prisoner is the son of parents as to whom he had no choice, and belongs to a race from which there's no way to resign. If Congress, in peacetime legislation, should enact such criminal law, I should suppose this court would refuse to enforce it. Justice Jackson correctly predicted that if he were to be remembered by posterity, it would be for his writing and for his service as the chief American prosecutor at the Nuremberg trials. As you already know, in 1945 and 1946, at the request of President Truman, Jackson took a leave of absence from the court to serve in that capacity. The major participants all agreed that Jackson was the guiding force behind the organization and implementation of the trials, and that his performance was masterful. In his opening address before the International Military Tribunal, Jackson said, "The privilege of opening the first trial in history for crimes against the peace of the world involves a great responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That four great nations, flushed with victory and stung with injury, stay the hands of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason." In March of 1954, Justice Jackson suffered a heart attack. His doctors told him that if he reduced his work activities, he could live a relatively long life. But he left the hospital on May the 17th and went directly to court so that the entire Supreme Court could be present when Chief Justice Warren announced the unanimous decision in Brown v. Board of Education. He soon returned to his rigorous work schedule. On October the 9th, 1954, a second heart attack killed him. He was 62 years old. In a memorial tribute in the Columbia Law Review, Justice Frankfurter wrote, "Self-reliance, good-humored tolerance, recognition of the other fellow's right to be and to thrive, even though you may not think he's as good as you are, suspicion of authority as well as awareness of its need, disdain of arrogance and self-righteousness, a preference for truculent independence over prudent deference and conformity, these were the feelings that shaped his outlook on life. He liked his kind without being sentimental about it. He was gregarious but shy about intimacies." In the same Columbia Law Review issue, one of his former Justice Department colleagues wrote, "He had a quiet courage which never led to a bellow of defiance, but which permitted him to take in any instance the action he thought best without discernible thought of criticism or personal injury. He was modest in manner, yet supremely confident of himself and his judgment. He had a calm which no crisis could disturb, and standards of honorable conduct which were both rigorous and unshakable. His splendid example makes me proud to be a lawyer and a judge." In the words of Professor Charles Fairman, he will live in the living law of the Constitution.
Thank you.
Send us forth renewed with hope, grateful for lives fully lived, inspired to be keepers of justice. Amen.